I am attorney Marie-Chris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, we shall aim to simplify the law. We shall explain concepts and principles of law in under 10 minutes. Hi! For this video, we will talk about the difference between a partnership and a corporation. Why is it important to know the difference between a partnership and a corporation? It's important to know the difference between the two, especially when you want to put up a business. Is it easier to put up a partnership? Is it easier to put up a corporation? If you want to put up a partnership, how do we do it? If you want to put up a corporation, how do we do it? So there are so many things to look into to decide as to what would you want to make. If you want to put up a business, is it a partnership on one hand or is it the corporation on the other? So let's begin with the manner of creating a partnership and the manner of creating a corporation. First off, you have to know the law that governs your partnership and the law that governs your corporation. Your partnership is governed by your civil code, while your corporation is governed by your revised corporation code or your RA 11232. This revised corporation code is quite new. This was enacted in 2019. So there are several changes from your old corporation code. Now let's get into the manner of creation, as I mentioned. Your partnership is created by mere agreement of the parties. In other words, if A and B will agree to create a partnership, then the partnership is created. And the manner or the form by which it is created, as a general rule, it could be written or it could be verbally made. Of course, there are exceptions, but let's not talk about that in this video. What we will need to know is that in creating a partnership, again, as I've mentioned, it's very easy. It's just by mere agreement of the partners. On the other hand, your corporation is created by operation of law. What does that mean? Of course, at the onset, you will have to agree with other people if you want to create a corporation. If you want to create a corporation, then you will have to apply for your registration before the Securities and Exchange Commission. And after complying with all the requirements that are required by law under your revised corporation code, that is the time when your SEC or your Securities and Exchange Commission will give you a certificate of registration. And that is the time when the corporation is created. So you see the difference. In a partnership, it is created by mere agreement. While in a corporation, you are not yet considered a corporation up until the state, through your Securities and Exchange Commission, grants you that registration, grants you that being a corporation, because your law, your revised corporation code, treats a corporation, of course, as an artificial being that is created by operation of law. So if you are into doing business and you would now ask which is easier to create, then of course, the obvious answer is that your partnership is easier to create than your corporation. Now, how about the number of partners and the number of incorporators? Is there a difference between a partnership and your corporation? Now, remember, I mentioned that our corporation code was revised just very recently. Now, before the revision of the corporation code, there was a minimum number of incorporators and a maximum number of incorporators. It should not be less than 5 incorporators, but not more than 15. After the revision, however, of the corporation code, the revised corporation code now does not give a minimum number of incorporators. However, it still has a maximum number. It must not be more than 15. Now, why do I say there's no longer a minimum number? In other words, you can create a corporation with just 2 incorporators. In fact, you can even create a corporation with you just being the incorporator. We call it the OPC, or the one-person corporation. Now, let's look at the partnership. Can you create a partnership with only one partner? The answer is no. Why not? Because your civil code clearly defines what a partnership is. And it says that a partnership is an agreement where 2 or more persons agree to contribute money, property, or industry to a common fund. In other words, a partnership should have at least 2 partners. You cannot create a partnership with just yourself, with just one person. Unlike now, your corporation. Again, prior to the revision of your corporation code, the minimum number of incorporators, if you want to form a corporation, was 5. That was the minimum. Maximum of 15. But now, with your revised corporation code, you can, in fact, create your own corporation with just yourself. Just you being the incorporator. And you call it your OPC, or your one-person corporation. Now, is there a separate juridical personality created when you form a partnership and when you form a corporation? The answer is yes to both. When you form a partnership, the partnership itself is considered another person, or a juridical person. When you form a corporation, the corporation also is considered as another person, another juridical person. Both juridical persons, they can transact business, they can enter into contract, it can rather enter into contracts, it can own properties, it can transfer properties. That's precisely why they are considered as persons. But of course, not a natural person, but as juridical persons. But what is the difference between the two? The difference now comes as to when the juridical person begins, or when the juridical personality of the partnership begins, and when will the juridical personality of the corporation begin. For a partnership, the juridical personality begins at the time of the execution of the contract. Meaning, once there's meeting of the minds, once they agree, the partnership is created. The juridical person of the partnership is created. Vis-a-vis a corporation, when will the juridical personality of a corporation begin? It begins when you have already the certificate of incorporation that is being granted to you by your Securities and Exchange Commission. Why? Because we said earlier that a corporation is created by operation of law. Another difference between a partnership and your corporation are the powers that may be exercised by both. Your partnership can exercise any power or powers or acts that are authorized by the partners, while your corporation can only exercise powers as authorized by law or as allowed by their registration, or those that are incident to its existence. How about as to management? Who manages the affairs of a partnership and who manages the affairs of your corporation? For a partnership, if there is a managing partner that is assigned, then he manages the affairs of the partnership. But if management is not agreed upon, who will now manage the affairs of the partnership? It will be all of them, because each partner will be considered as an agent of the partnership. How about the corporation? Who manages the affairs of the corporation? That power to manage is vested in the board of directors for stock corporations and in the board of trustees for non-stock corporations. How about the effect of mismanagement? If there is a partner who mismanages the partnership, then the other partners can sue that partner. How about in a corporation? If a member of the board of directors or the member of board of trustee mismanages, then it shall be in the name of the corporation. The corporation will sue the mismanaging member of the board of director or the board of trustee. Another difference between a partnership and a corporation is the extent of liability of the partners and the extent of liability of your stockholders in a corporation. In your partnership, the general partners may become subsidiarily liable to the debts of the partnership with respect to third persons. In other words, if the partnership no longer has any property with which to pay off the debts of the partnership to third persons, the third persons can go after the general partners. Why am I saying general partners? Because there are what we call also as limited partners. They're called limited partners because they agree only to be to have rather limited liability. So the third persons or the creditors of the partnership cannot go after them. But as a general rule, for general partners, they can be made subsidiarily liable. And in certain circumstances, which will be subject to another video, they may be solidarily liable even with the partnership. However, with respect to stockholders of a corporation, their extent of liability will only be limited to what they have subscribed in the corporation. In other words, the creditors of the corporation cannot go after the individual stockholders. They can only go after the corporation. Of course, there are also exceptions to that, but as a general rule, the corporate debts will be answered by the corporation, and the third persons or the creditors cannot go after the stockholders. Another difference between a partnership and your corporation is the transferability of interest. In a partnership, a partner cannot merely assign or transfer his interest in the partnership without the consent of all the partners. Why does he need consent of all the other partners? Because a partnership is based on trust and confidence. Because it is based on trust and confidence, the partner cannot just simply sell his interest and have another person admitted into the partnership. It has to be with the concurrence or agreement of all the other partners. While in a corporation, if you are a stockholder, you can simply sell your interest in the corporation, and you do not need to ask permission or have the consent from all the other partners in you selling your interest or your shareholding in a corporation. Why? Because it is not based on trust and confidence, unlike your partnership. Another difference between your partnership and your corporation is the term of its existence. A partnership can be for any term or duration, depending on what the partners agree on. While your corporation, okay, this is another amendment in the revised corporation code. Now, your corporation can have perpetual existence, except when it is provided for otherwise in their articles of incorporation. Prior to the revised corporation code, in the old corporation code, there was a limitation in the duration or in the term of existence. It was only for 50 years, renewable for another 50 years. However, in the revised corporation code, your revised corporation code or RCC now tells you that your corporation, as a general rule, has perpetual existence. Another difference between a partnership and a corporation is its dissolution. In a partnership, it can be dissolved anytime by the will of the partners. However, your corporation cannot be dissolved without the consent of the state. That means you have to go through again your Securities and Exchange Commission to ask that the registration of the corporation be terminated so that it will now be considered as it no longer existing. Unlike in your partnership when your partners can just terminate it at will. Again, however, in a corporation, it must be with the consent of the state. That's it for this video. I hope you learned the distinction between your partnership and your corporation. If you have learned anything from this video, please feel free to click like and subscribe. If there is any other principle or concept of law which you would want me to discuss in this channel, please put them in the comments section below. Thank you for watching. See you next time in MBL Classroom.